So here's a question for you. What happens when a country gives its citizens a fundamental right, but for years, not a single person can actually use it? Today, we're going to dive into the incredible story of a law that was basically just ink on paper, and the one landmark case that finally brought it to life. So let's go back a bit. In 2018, India's Supreme Court made this huge announcement. It officially recognized the right to die with dignity as a fundamental part of the right to life. A core constitutional guarantee. This was a massive deal, a really big step forward for individual autonomy. But after that big declaration, well, nothing. For 8 long years. For all that time, the right was what lawyers call a dead letter. A great phrase, right? It means a law that exists in theory, but in the real world, it's impossible to use. The whole legal process was so complicated, so unworkable, that literally no one could successfully access this right. It was a right in name only. But then, one single, heartbreaking case changed everything. It forced the courts to finally close that gap between what the law said on paper and what was happening to real people. So let's talk about Harish Rana. Because in March of 2026, his story led to this absolutely unprecedented judgment that for the first time ever put that 8-year-old law into action. Okay, so back in 2013, Harish Rana was just a young student. He had a tragic fall, suffered these devastating head injuries, and for the next 13 years, he was in a permanent vegetative state. The only thing keeping him alive was a feeding tube, one that had been surgically put into his abdomen. So after this long, painful legal fight by his family, the Supreme Court did something it had never, ever done before under that 2018 law. It gave permission to withdraw his life support. That dead letter, it had finally been delivered. But a decision like this doesn't just happen in a vacuum. To really get why this moment is so important, we actually have to go back in time to another woman's story that started this whole painful journey. And that is the story of Aruna Shanbhag. She was a nurse whose personal tragedy ended up becoming the flashpoint for India's entire debate on the right to die. Way back in 1973, Aruna was horrifically assaulted at the hospital where she worked. The attack left her in a vegetative state for, it's almost hard to comprehend, 42 years. And after nearly 4 decades in that state, her case finally made it to the Supreme Court. And this is the part that changed everything. The court, looking at her case, legalized what's called passive euthanasia. Now, that just means withdrawing life-sustaining treatment to let a natural death happen. For India, this was a historic first. But here's the incredible irony. The court denied the request for Aruna herself. So why? Because her caregivers, the nurses at her hospital who had looked after her for decades, they wanted her to live. They said they loved her, that she was like family. So the law changed because of her, but her own suffering went on until she passed away in 2015. So Aruna's case cracked the door open, but it took another really big judgment to formally create the right that Harish Rana's family would end up using years later. And that came in 2018. It was a case called Common Cause versus the Union of India. And this is when the Supreme Court declared that the right to life must also include the right to die with dignity. I mean, what a powerful, progressive statement. But, and this is a big but, here's where the problem started. The procedure the court created was just unbelievably complicated. I mean, just look at this flowchart. It involved all these different steps, a 2-tier medical board approval process. It was such a mess that they had to simplify it in 2023. And even after they simplified it, the whole thing was so intimidating that no one used it. It just sat there until the Rana family decided to put it to the test. So this brings us right back to Harish Rana's family. They took this right that only existed in theory and decided they were going to try and make it a reality. And their journey was just agonizing. They fought for over 2 years, only for the Delhi High Court to reject their request in 2024. The court basically said, sorry, your son's situation just doesn't qualify. And this right here, this gets to the absolute heart of the legal battle. The High Court's view was that removing a feeding tube is active euthanasia. They said it's just basic care, like food, so removing it is like starvation. But the family's argument was, no way, this is not a meal. This is a medical intervention, a surgically implanted tube that is artificially prolonging his suffering. Everything hinged on that one question. So, when the case finally made it up to the Supreme Court, the judges knew they had to settle this once and for all. And their 2026 ruling just dismantled that core argument, piece by piece. First, and this was absolutely crucial, the court gave a clear definition. It said, okay, clinically administered nutrition and hydration, or CANH for short, is officially a form of medical treatment. A feeding tube is not the same thing as a meal. It is a medical intervention, period. And from that one decision, everything else followed. You can see the ripple effects here. Because CANH is medical treatment, it can be withdrawn. The court also totally reframed the idea of the patient's best interest. The question they said isn't, should life end? The real question is, should a treatment that is artificially prolonging life continue? And they made it super clear. This right applies to anyone in a permanent vegetative state, not just people with a separate terminal illness. And this is a profound shift in legal and medical thinking. It completely flips the script. Before, the burden of proof was on the family to argue why treatment should stop. Now the court is saying that in futile cases like this, the burden is on the treatment to justify why it should continue. The intervention itself has to prove its worth. So this huge decision in Harish Rana's case has finally made the right to die with dignity a practical reality in India. But it also opens up a much bigger question about what comes next. You know, the court itself pointed this out. Without a proper law passed by Parliament, this right is still really vulnerable. It's mostly accessible to people who have the money and resources to fight these long, expensive court battles. So the real question now is, the court has drawn the map, but will the government actually pave the road for everyone?